So good morning. I'd like to welcome you to the first Opacity Policy webinar, which is Changes to General Immigration and Citizenship Policies. My name is Erica Gates-Gass, and I'm the Policy and Research Coordinator. And we've been very pleased with the response to both this and the other webinars that we're offering. We actually have over 100 people who are registered for today. But although with group viewings, we estimate that there are going to be close to 300 people participating, which is really great. And this is the first webinar in our series, and if you'd like to know more, you can go to CASI.org for more information. We're currently organizing a webinar on the Canadian Revenue Agency rules related to advocacy limits, which we'll be announcing soon, and other webinars are also in the works. Just one note, that only one person can access from each registration link. So if you did receive a link and you forward it to other colleagues, only the first person who accesses through that link will actually be able to view the webinar. So please keep that in mind. But also we will be recording this webinar and it will be available online for folks who want to listen to afterwards. Now I want to give a big welcome and thank you to Amy Go. She's the Clinic Director of Metro Toronto Chinese and Southeast Asian Legal Clinic and will be doing our presentation today. She's served in her current role since 1992, and since her call to the bar, she's worked exclusively in a legal clinic system, serving the legal needs of low-income immigrants with linguistic and other barriers in accessing the legal system. Now, I'm going to take you through just a few things in terms of participating. On your screen right now, you should see something that says how to participate today. So I'm going to take you through a few things. The first, you should have a control panel on your own screen that's on the right-hand side. And so on the screen that you can see that I'm showing you here, you should be seeing it twice, on the right-hand side and then on the left-hand side, which is our PowerPoint. So you can, let's get this PowerPoint working here. So now you should see, it says open and close your panel. To do that, there's a arrow on a red box, and if you touch that, it'll close your panel, as you can see on the PowerPoint, and if you touch it again, it'll open it back up. Now, if you click on View, you can change the way that you view on your entire screen, so you can see full screen or window. Now, the next thing to view and test your audio, you should be able to see there's that red square box, and it shows there whether your audio is working, but we actually won't be turning audio on today, so everyone will be muted, and we'll be submitting our questions by typing. But that audio stuff is where you can check. Now, to submit your questions, you have that question box there, and you'll notice on the PowerPoint, there's a little minus sign. If you can't see your whole box, you should have something that says questions, and if you touch the button beside it, that'll open up the box, and that's where you can type in your questions. And we'll be keeping track of those throughout the webinar, and then at the end, the last 20 minutes or so, we'll be using those questions. Maybe we'll be answering some of those. If you're also having any problems hearing the webinar or anything else like that, you can type in any problems that you're having there, and we'll try and respond and support you with any tech problems there. Now, there's this raise the hand thing, but that's not applicable to us since we're going to be doing typed questions. And so again, just finally, the webinar will be recorded and posted on ocasi.org at the end. So you should, by the end of the week, so you should be able to access it there. So in terms of format, the presentation will be about 40 minutes long, and then we'll do about 20 minutes question and answer at the end. And hopefully, I hope you enjoy this webinar, and now I'm going to pass it on to Amy.
Thank you very much. So although I have done webinar in the past, usually somebody else is controlling the computer for me, so I didn't have to do anything. So this will be the first time I'm doing the webinar, and I guess changing the slides at the same time while I talk. So hopefully there won't be any glitches. Thank you very much, Cassie, for inviting me here to talk about some of the recent changes to Canada's immigration policy and citizenship laws, and to look at the impacts on the permanent residents in Canada. In my presentation this morning, I'm going to focus on the following changes. First of all, changes to the language requirement for citizenship. Then I'm looking at the super visas for parents and grandparents, followed by changes to the federal skilled workers clause. And then finally, I'll touch on just briefly on the conditional permanent residence requirement. So the first thing, I'm going to start with the changes to the citizenship language requirement. I guess the first thing that people should know is that under the Citizenship Act, adequate knowledge of one of the official languages of Canada is a requirement for granting a citizenship application. So that's in under Section 5, Sub 1B of the Act, if you're interested in knowing the section. And then the Act itself doesn't really talk about what is adequate requirement and how do you go about assessing it. And in the regulations that's under the Citizenship Act, Section 14 then talk about a little bit more about the criteria for determining whether someone has an adequate knowledge of English or French. So, and it states that it is to be assessed based on the person's comprehension of basic statements and questions in English and French, as well as the person's ability to convey basic information and to answer questions either orally or in writing. So that's sort of in the regulations under the Citizenship Act. In addition to the Act and the regulations, there's also the Citizenship Immigration Canada Policy Manual. In this case, it's CP4. You can find it on the Citizenship Canada website, www.cic.gc.ca. So look under, sort of publication policy manuals, and there are a number of different manuals. One of them, CP4, is about granting of citizenship application. So in the manual itself, it talks about the granting and the knowledge and the language requirement. Particularly, it says the applicants for a grant of citizenship citizens must have an adequate knowledge of either English or French. This means being able to communicate in everyday situations such as shopping, using public transport, understanding simple questions, conveying information reliably, and so on. And so prior to November 1st, 2012, applicants who apply for a Canadian citizenship usually will have their language assessed after they submitted the application, and most of the applicants will then be required to write the citizenship test. But even when the applicants are writing the test, sometimes, like we heard, that officers from CIC will kind of, talk to the applicants, use their interaction with the applicants to determine if they actually meet the language requirement. And if an officer has concern about an applicant's language ability, the officer may then require the applicant to be interviewed by a citizenship judge. And it's during that interview, the judge will then determine whether the person actually is able to speak English or French adequately. So, but then that was before November 1st, 2012. As of November 1st, 2012, however, the process has changed with respect to proving the language requirement. So it's the process of proving whether you have the language that has been changed, but the adequacy of requirement hasn't been changed in the sense that the Act hasn't been changed, neither has been the regulations. So the two provisions that we talked about earlier are still the same. But then now, as under this new process, the applicant has to submit proof of their language ability at the time of their citizenship applications being submitted. And the proof of the proof is stated in the policy manual, which says the person has to submit proof of achievement of Canadian language benchmarks, CLB level 4 or higher in speaking and listening, and then that proof has to be submitted at the same time as their application. And the list of what is acceptable evidence is actually provided again in a new Operation Bulletin 469, and it's in Appendix A. Again, this information can be found on the CIC website. But it's important to note that if you do not submit the proof at the time when you make your application will be returned to you. So what are some of the acceptable language evidence? So, there's a list like, so for instance, successful secondary education completed in English or French, some kind of a score that confirms they have met the requirement of level 4 or higher. So you can actually go to the website, take a look at the Appendix A, and find out what is and isn't acceptable proof. But there are people, even under the current legislation, there are people who, for whatever reasons, are not able to meet the language requirement. And so prior to November, some of them will be asking the citizenship to waive the language requirement. And so after November 1st, they can still do the same thing. However, again, the process of making that request has changed again. So under the new rule, applicants who have, well, this is according to the bulletin of CIC, it says applicants who have a cognitive disability, which prevents them from providing proof of language ability, will need to explain on the application form the nature of the disability, and then also provide documentary evidence in support of the condition. And there must be at minimum one piece of supporting documentation included with the application. So I guess one particular concern I have is that, in fact, the Act itself does not really say that that you have only people who have a cognitive disability can ask for a waiver. In fact, under Section 5.3 of the Citizenship Act, the minister may, in his discretion, waive on compassionate grounds the requirements of language and knowledge of Canada. So the Act doesn't say that only people who have a cognitive disability. It says on compassionate grounds, the minister can waive the requirement. So I think I'll be interested to see if there will be individuals who don't have a cognitive disability, but then for other reasons are unable to acquire English language, and whether they will be able to get the waiver under this new rule. So it is something that perhaps settlement agency workers, I would suggest that you keep an eye out for. And perhaps if there are clients who are in that situation who don't really have cognitive disability, but they should be waived because on compassionate ground, perhaps to consult legal clinic or talk to Cassie about this issue, because I would be interested to find out. So what will be some of the impact of the change? Well, I think that there will be more delay because not everyone will be aware of the fact that they have to submit these proof, or maybe they can't get the proof at the time when they apply and the application gets sent back, or because they have to get the proof, so it takes more time for them to get the proof together in order to make the application. So all of this will cause delay. And I also think that there will be more refusal. Even though the rules are not supposed to change the requirement, however, I think it will be hard-pressed for a citizenship judge to say to someone who is unable to submit the proof to show that they are able to meet the level 4 requirement, and then for the citizenship judge to agree that that person actually meets the language requirement. So I think, in effect, while the minister has said that this doesn't change the standard, in actual fact, I think it will. And therefore, I think it will make it harder for certain people to become citizens, and in particular, immigrants and refugees from non-English speaking countries. And then also family class immigrants, because they do not have to meet the language requirement when they apply for immigration. So therefore, many of them will not necessarily meet the level 4 requirement as specified under the new rule. So many of them might also likely be turned down in their citizenship application. And what is very disconcerting, in fact, is that over the last several years, we are seeing a declining trend of rate of citizenship applications and in general. So here's the information from LexBase that shows that for people who are landed in certain years, eligible to apply for certain year, and the percentage of them who actually become citizen, then you can see very clearly that the percentage continues to decline over time. And of course, the last few years, probably some of them will eventually apply, but still, overall trend is in decline, so I think that's very disconcerting. So I'm going to, sorry, I'm just going to, now I'm going to turn to my second topic, which is super visa for parents and grandparents. And the first slide is just to talk about in the regulation of the Immigration and Refugee Protection Act, mothers, fathers, grandfathers, grandparents, like, they are part of the family clause. And that hasn't been changed, so it is still in the regulation. And therefore, if you're a citizen or a permanent of Canada, you are supposed to be able to sponsor parents or grandparents under the family clause. However, as I think all of you probably know by now, there's a moratorium on the sponsorship of parents and grandparents as of November 5th, 2011, and therefore there's no new application received since then, and then the moratorium will remain in place until November of this year. I want to emphasize that, as I mentioned, there is no change in the regulation. What the minister did is to, by way of the ministerial instruction, he imposed this moratorium. And this authority for ministerial instruction came from, this particular section 87.3 of IRPA, which was a new section that was introduced in 2008 when I think Diane Finley was the minister. And so this gives the minister power to do a number of things, including, for instance, they may just declare that whole category or whole sort of category of applications be set in a particular to 0. So they basically said for these 2 years, the category of parents and grandparents applications will be set to 0. So that's how they get around the legislation. And so under the grandparents and parents super visa, these are the requirements to be found admissible to Canada. You have to also meet other conditions. And what the note that highlights here is that unlike the sponsorship, like in the past, for instance, when someone is applying for their parents and grandparents, very often you would also include the person's, the sponsor's siblings as dependents on the parents, and that's how the extended family members are able to be sponsored to Canada. However, the super visa does not apply to dependents of your parents and grandparents, meaning your siblings will not be able to get the super visa to come to Canada. And so the visa officer still has to consider certain factors, just like they consider any other visitor visa. They will look at the person's ties to the home country, purpose of visit, financial situation, and so on and so forth. So they can still deny you if they think that you don't have a strong enough tie to your home country, or if they think that you're going to come to Canada and you're not going to leave. Those factors will still affect your application. And also, you have to have, the sponsor must have meet the minimum income requirement or the LICO requirement. And the applicant themselves have to pass the medical test. But also, they also have to pay for medical insurance that provides a minimum coverage of $100,000 or more before you can even apply for it. So, one of the concerns I have, and I think many people have, is that with the LICO requirement on the sponsor and the medical insurance requirement, that means if you're not rich, you're not going to be able to afford to apply for the the super visa. And secondly, as I noted earlier, the dependents, meaning the children of the grandparents and parents, are not able to get the super visa. So they will still have to go through the visitor visa applications, as well at the same time they will not be able to be sponsored to Canada. So I think it's really a missed opportunity for Canada to have more family class members, including the younger family class member, the younger people that Mr. Jason Kenney seems to want to attract. These are the children of the parents, grandparents, these are our siblings. They will not be able to come to Canada for the next 2 years. But also I think that this particular, the moratorium and the visa requirement is going to have a disproportionate impact on people of Chinese descent and South Asian descent. Why? Because the majority of the people who apply for to sponsor grandparents and parents are people from China and India. Like, you know, the children are here and they try to bring their family over. These are the communities who tend to embrace a more extended family concept. Parents are just as important to us as our siblings and our spouses. And so the moratorium will have a direct impact on these communities. So overall, I think it's a, I think it's a negative trend, even though I think the government tried to suggest that, it's a positive thing, like, it's make it faster for people to come to Canada, without recognizing the reason why it took so long for grandparents and parents to come. It was because the government was not putting in the resources to process sponsorship of parents and grandparents. Now, with that, I'm going to turn to the Federal Skilled Workers Program. There's been a lot of changes, and so it's hard to keep track, and it's impossible to cover all of them. So I'm just going to, I guess, review some of the major changes, including these 4 areas. So in addition to these 4 areas, the government has also announced some other changes, like minimum language testing for people who are applying through the provincial nominee class. They created a particular class for people with PhD. I'm not going to talk about those things. The government has also proposed a model of expression of interest. I will touch on that issue. But I'm going to start with the elimination of the backlog. So in March of last year, CIC made this bombshell announcement that they're going to close the files for all the federal skilled workers applicants who applied before February 27, 2008, and for whom an immigration officer has not made a decision based on selection criteria by March 29, 2012. And this is an announcement that affected about 300,000 people, including their dependents. And only about 20,000 of them will see their applications continue processing because they have passed that selection criteria by that point. And according to the government, the decision to eliminate the backlog is prompted by the desire to create a fast and flexible immigration system that creates jobs and promotes Canada's long-term prosperity. However, several class action lawsuits have been filed, since then. The first action was filed on behalf of about 900 applicants, and it was partially successful. But then subsequently, some of the class actions, they're trying to get the federal court to impose an injunction to force the government not to stop the processing. That was not successful. However, there was an agreement that the government will kind of stay, they will not start processing the refund until the court case, until the next stage of the court case is finished. So there's still some ongoing kind of litigation in this area. So at the same time, while the government eliminated the backlog, and in July they suspended further applications of new federal skilled workers class, they are floating out a lot of hot air balloon, trial balloon, to talk about some of the possible changes that they're going to introduce in the future. And one of that ideas is the expression of interest model, the EOI system. And they said that, this is like a federal, provincial sort of collaborative effort. They want to put in place this model to move to a quote-unquote just-in-time system to recruit people that the governments consider to be a right match with Canada's labor market. So what exactly is the expression of interest model? Well, the press release that was introduced by Citizenship back in November 2nd, 2012, they refer to this model as based on some of the other countries, including New Zealand. So I then take a look at the New Zealand model, which is basically a 5-step model. The first stage is they ask applicants to do a self-assessment. So you go online, there's like some kind of form, you type in your information, and then you figure out whether or not you would even meet the requirements. And if you think you meet the requirements, then the second stage is you put in your expression of interest. So there's another form that you fill out, and then you submitted the expression of interest. And then once it's submitted, the expression of interest will be periodically selected from the pool by the government of New Zealand. And they have a point system as well. The points are different, but applicants that exceed 140 points will be selected automatically, while those lower than 140 but more than 100 points, they may be selected. Once you're selected, the government will then send you an application form for you to submit an actual application for residence. And one thing to note is that the expression of interest, they will keep you on file for about 6 months. So if you don't apply within 6 months, or they don't select you within 6 months, then your application, their expression is expired, and you have to start the process all over again. And once your application is in, then they will make the decision to accept or not accept. So the new system, might be similar to something like that. Moving now, because I'm running out of time, so moving out as of January 2013, the government also created a new federal skilled trades stream, which will accept applications from about 3,000. And basically, you have to meet certain requirements, often employment in Canada. You have to meet the basic language requirement, has a minimum of 2 years of work experience, and skills and experience that match some kind of an occupational list. And there are, in fact, 2 different lists. List Group A and Group B. And then they have Group A are the jobs with moderate labor market needs, and Group B are the so-called in-demand jobs. And they have a cap for the applications for Group A and no cap for Group B, but the overall cap will be 3,000. So these are some of the jobs, that are included in Group A. I'm just giving you a sense of what they are. A lot of oil and gas drilling, drill, drill, baby, drill. More drilling, more mechanics in Group B. Sort of ironwork, electricians. So it's supposed to be the semi-skilled and skilled workers, which is a good thing. But at the same time, you still have to meet the language requirements. So, I'm not sure how many people, let's say from China, would actually qualify. Anyway, so moving on to the next thing, there are changes to the CEC class to make it a bit easier for people to apply, for a program, because you have more time to meet the requirements, and graduates also have more time to earn their 1 year of work experience. But this is the new change that I think everyone will be interested to know and be watching out for, and that's the new selection system for the Federal Skilled Workers Program, which is going to be in effect as of May 4th of this year. In a nutshell, it's going to increase the language requirement. It's going to give more emphasis on younger immigrants. There's going to be a credential assessment, new credential assessment process, as well as changes to the adaptability points for spousal language ability and work experience. So under the new system, the language is now the largest, or take up the largest points or highest point, or the largest proportion of the points, a 28-point maximum. And age will be 12 points, but only people who are under the age of 35 will get the maximum points, with diminishing points awarded from 35 to 46, and there will be no points after 46. The education points will also be different, and they are now going to ask the applicants to actually get some kind of a credential assessment ahead of time to show that their credentials will be recognized in Canada before they would even let you apply. And also the work experience, they say that the work experience is a weak indicator of success, like your prior work experience, and that's why they reduced the work experience to 15 points. So what do all these changes mean? I think that it will mean, first of all, that the source countries of immigrants to Canada will change. Because of the changes to the language requirement, I think it will privilege countries that are English-speaking and put people in a non-English-speaking country in a disadvantage, and that means that much of the global south. It will also change the makeup of immigrants because, while they say work experience is not the most important part, and they try to suggest that they are looking at different ways of looking at education. However, education is still very much a very, I guess, important part of the point system. But also, the pathway to immigration will be different in the sense that, because if you have to have your credential assessed, and given the systemic barriers that exist in many of the fields and professions that we know of, including the fact that many countries such as China, India, people from those countries are having a hard time having the credentials recognized in Canada. So that means that people from those countries probably will not be able to provide the assessment or the credential assessment that is needed in order to apply for term residence under this class in the first place. And I think apart from the changes to the point system, the previous stuff that we talked about, the changes to CEC, the provincial nominee, all of this thing, I think what it means is that people will then try to come to Canada earlier, whether they try to come as temporary foreign workers, or they will send their children to come to Canada to study in the hope that the children will then be able to apply through the CEC class or the graduate student class or PhD class. So it is going to change the pathway to immigration. But it also means that only those who can afford to send the children abroad to study will be able to take advantage of those changes. So mean the richer people are going to come in, whereas the poor will be left out. However, things are, not, while it may not look very good for some, for others, things are definitely looking up, and I'm just here giving you an example of what is looking up for Irish youth. The number of Irish youth that will be admitted through the International Experience Program will be doubled to 10,000 beginning in 2014, just to give you a contrast of some of the changes that have been happening. So finally, I want to touch on the conditional permanent residence issue. So I understand that the OCASI will have a website, a webinar to talk about this particular issue. I'm not going to, sort of review it in much detail. But just to know that as of October 25, 2012, spouse, common law, conjugal partners who are in a relationship of 2 years or less at the time of the application, or if they have no children in common with their sponsor at the time of the sponsorship application, are subject to 2-year conditional permanent resident, 2-year conditional resident. So basically, it's a condition. It is not a condition that you need to meet at the time you apply, but then within the next 2 years after you come, you may be called upon by the officer from CIC to see if you have met the 2-year requirement. And what this 2-year requirement says is that you have to stay in a conjugal relationship with your sponsor for 2 years after you are landed in Canada. So not only you have to live with your sponsor, but you have to actually have a conjugal relationship with your sponsor after 2 years, within 2 years after you come to Canada. There are exceptions to this requirement. If you can prove evidence, like submit evidence of abuse by your sponsor, neglect, or you can show that your sponsor has failed to protect you from abuse, neglect during the conditional period, including failure to protect you from other people, like other family members who may be abusing you. And the other exception is, of course, the death of the sponsor. I mean, I guess they can't really expect you to live with the sponsor to 2 years if your sponsor is dead on upon arrival in Canada. But any event, so those are some of the exceptions to this requirement. And as you can imagine, there are many people who are concerned about this rule. While we are pleased to see that there is exception for people in abusive relationship, but the fact of the matter is, many women, in particular, in abusive relationship, do not often report abuse. So proving the abuse would be a very difficult thing for them. And so there are a number of organizations such as OCASI, YWCA, and our clinic are working on a campaign to try to change the conditional permanent residence requirements. So there will be more details as the campaign. We're still working out some of the steps that we want to take, and I'm sure OCASI will share with you more details in the future. So apart from the problem of proving abuse, and proving abuse might be possible if you file the police report. Neglect, I don't even know how people prove neglect. But finally, more importantly, how do you prove that you are in a conjugal relationship? That's really, like, are they going to come into your house to, inspect your bedroom, check your wastebasket, or you see the condoms or anything? So this is my suggestion for people who are thinking of how to prove conjugal relationship. Do what Monica Lewinsky do. Save the blue dress. Keep the DNA evidence. Otherwise, I don't even know what else you can do to prove that you have been in a conjugal relationship with your sponsor. So with that, that's my webinar presentation. If you have any questions, I look forward to answer them.
Great. Thank you so much, Amy. So we do have a few questions, and I encourage you, if you have any other questions, to please type them into the question box, and we will answer them. So the first question that we have at the moment is, clients attending credit courses to achieve a Canadian high school diploma, would that be acceptable as language proof?
Okay. So the question, okay, let me just look at Appendix A, So for people who are in the secondary or post-secondary education, what the Appendix A says is that you need a transcript from a secondary or post-secondary school indicating the successful completion of a program in English or French in Canada or abroad, or a diploma or certificate indicating successful graduation from a secondary school or post-secondary school in English or French in Canada or abroad. So I guess if you're taking a credit course, you get a transcript that shows that you have a successful completion of the course in English or French. I would think that that will meet the requirements. So that would be my guess, based on the reading of the Appendix A of the Bulletin 469.
Okay, so we're going to stay with questions around language. There's also a question, are applicants from English-speaking countries required to submit language requirements? And, I'll just leave it at that for now.
So you're talking about, again, the citizenship requirement, right? So all applicants now have to submit the proof of the language knowledge requirement, regardless of your country of origin. So they're not saying that only if you're from a country that is non-English speaking that you have to submit the requirement. So I guess the question is, how do you go about getting the requirement, the certificate? I don't really know, I think there are some suppliers or providers who will do the test, maybe some private agencies that will do the test for you if you pay a fee. And then, because I know that certain groups like YWCA has indicated that they will not do that unless you are actually a student that is taking a course at YWCA. That's my understanding. I could be wrong. But in any event, there are, I guess, different providers who do that. So, which adds to another burden, right? Meaning people will have to pay to get the certificate to show that they have passed the test before they can even apply for a citizenship.
Okay, so again, related to the language questions. So we have one, if the applicant's mother tongue is English, what proof can be given? Should a letter be submitted? And then there's another one here. So I think we just can't answer that. And so what about ESL for language requirements? Many clients spend years doing ESL before they are eligible for LINK courses. If they came in as refugees, by the time they are eligible for LINK as protected persons, they are working and have sufficient English.
Okay, so in terms of the, again, I would encourage you to look at Appendix A on the Bulletin 469. What they say about LINK ESL is that applicants who successfully completed LINK CLIC, I don't know what CLIC is, I guess maybe that's French, training will be issued certificates which can be submitted as evidence. For applicants who successfully completed LINK between January 1st, 2008 and October 31st, 2012, they were not always provided certificates of completion. So applicants will specify on the application form that no certificate or evidence is available to include with the application. An electronic verification process will be conducted at the CPC Sydney, like the Case Processing Center in Sydney, Nova Scotia, to verify those clients who are unable to provide a certificate. And then these files and results, they will conduct, if they can actually show that they have, you have some kind of verification result, they will still accept it. But if they have any concern, then they will refer you to the citizenship judge for a hearing.
Okay. Now we have a question, what happens to those who do not meet the language requirements and therefore cannot apply for citizenship? How long can they maintain their landed immigrant status? And along with that, do the language requirements for citizenship apply to people over the age of 55?
Okay, I'll answer the second question first. That's the easy one. It does not, the language requirement does not apply to people over the age of 55. For people who are not able to pass the language requirement, and assuming that they have no compassionate reasons to apply for a waiver of the requirement, they basically will remain permanent residents until I guess they, they reach the age of 55, and then they will apply, and even without the language requirement. So, and they can stay as permanent residents as long as they, I guess, meet all the requirements of being a permanent resident. You stay in Canada for every 2 years out of 5 years. You do not have any, sort of like criminal. Well, I guess there are changes going to be the criminal admissibility as well. It will be, which will make it easier for government to deport people with criminal record. But subject to those kind of concerns, as long as you live in Canada, stay as a resident, then your permanent resident status will be kept as long as you meet the requirements, and until you reach 55, then you can become a citizen. So it is a big concern because that means many people who are unable to meet the language requirement will not become citizen, will not have the right to vote, and also they are often at risk of losing the status because of all the ongoing changes that are made to the immigration legislation. And as we see, the number of people who are becoming citizens is declining over the years, which I think is a concern for our country as a whole. It's really undermined our democratic process as fewer and fewer people are able to participate in the electoral process. It also, I think, does a lot of damage to a person's sense of belonging, that you are forever a non-citizen in the country that you call home.
Okay, so now we're going to move to a few questions related to the super visa. So there's a question of clarification. So within these 2 years, November 2011 to November 2013, the question is our parents and grandparents only able to come with a super visa? Is that true? And then the other question is what's going to happen. I'll leave that question first.
There might be parents and grandparents who are being landed within this 2-year period because their applications were submitted before November 2011, and because, as we know, it takes on average about 7 years to process a sponsorship of parents and grandparents. So there are, chances are there are some applications that were submitted, like, in, let's say, 2005, and then people are being landed today. So it's not entirely true that parents and grandparents are not coming in Canada today, other than through super visa. But that's because they had submitted the applications years ago. If you're a new applicant, meaning you're just starting your application now, you cannot do that under the sponsorship program. You can only apply through the super visa.
So a quick question again to the super visa. There's a question, can grandparents who are failed refugee claimants apply for the super visa?
They don't. There's nothing in the rule that says anyone else but failed refugee can apply. However, if you recall, one of the slides talked about the factors to be considered by the visa officers, including the person's tie to the home country, the purpose of visiting Canada. So I don't know if the visa officer may decide that if you are a failed refugee claimant, whether your tie with your home country is sufficient, or whether they're going to, I guess, question your intent of coming to Canada and use those grounds to refuse your visa. So, it's not categorically no, but because of the factors that are being used by the visa officer, that I think there is a chance that a person who has tried to submit an application for refugee before may be deemed, as someone who should not be able to come under the super visa.
Okay. Now, just a question around conditional permanent residency. What's going to happen if the sponsor dies before the end of the 2 years of conditional permanent residency? Is the remaining sponsored spouse going to have to go home, or can they stay?
Okay, thank you for the question. So maybe I should clarify a bit more. I kind of rushed through it because I ran out of time and I thought there's somebody else who to talk about it. So the 2-year condition, what it means is that within those 2 years, you're required to live with your sponsor in a conjugal relationship. And then there are the exceptions to those rules, right? So the exceptions include the death of the sponsor. So if your sponsor died, that condition then ends, meaning no condition will be attached to your permanent resident. So if there's no condition attached, your permanent resident status will continue on. So you can continue to live here, and you won't be facing deportation because you failed to meet the 2 years requirement.
Okay, another question related to the super visa. If a parent is currently in Canada with a visa, and I'm assuming they mean just a regular visit visa, can they change over to a super visa?
I don't know the answer to that question, whether you can change over. I suspect that you have to apply for super visa as opposed to a changeover. Yeah, I don't think that, I think they will treat it as a new application as opposed to changeover. So I think what happened is that instead of renewing your visitor visa, then you just apply for a super visa instead.
So again, related to the super visa, there's a couple questions around what is the maximum length of the super visa in terms of how long does it last, and then there's also a question of what's expected to happen at the end of it. What happens? Can they stay? Go?
The super visa, the longest, it will last up to 2 years. So if you're given a 2-year super visa, then you can stay for 2 years. And then at the end of it, now because the whole moratorium is for 2 years, the super visa is for 2 years, I don't know if the government is going to renew this super visa program after the 2-year period, or whether they are going to allow grandparents and parents to be sponsored again. So I don't know if at the end of the 2 year, whether there will still be a super visa program, or whether you can, if there's no such program, then perhaps you could try to apply for a visitor visa at the end of the 2-year period.
Okay. And again, so there's another question that if the parent is under 50 years old, is the applicant, can they still apply as a super visa, or will the family class option be
available? The program applies to grandparents, irrespective of age. So they are not looking at only parents who are over the age of 50 or, or under the age of 65 or anything like that. Because as I mentioned, the family class definition is looking at your relationship with your sponsor. So if you're the parents of your sponsor or grandparents of your sponsor, then you will now be subject to this super visa requirement or super visa program. So yeah, so the same rules apply. But I guess if you're a younger parent, then maybe your medical insurance will be cheaper, so it may be easier for you to get here.
Okay, so just I only have a few minutes left, so I'm just going to move back to a few questions around language. And first, I just want to know, we did get a note here from someone working at the YMCA Language Assessment Center, and they just wanted to know that the YMCA doesn't offer any language training. I believe that Amy mentioned this. They don't offer training; they just offer the assessment that then is used, that is required for training. So I just want to mention that, and there's some other points there that we're going to send out in an email. Now, those other questions. Well, what type of document do you require to prove language disability, or to prove disability in terms of language requirements?
Now, so they talk about a medical opinion because right now the rule talk about the waiver as it only applies to people with cognitive disability. But as I mentioned, I disagree with that interpretation of the Act, right? So be that as it may, so they're talking about medical opinion, but so it could be under the current application. So someone who applies for waiver will be given a medical opinion form. So usually you have to take that form to a doctor, and the doctor will explain what is the medical condition and why is that, sort of like whether in the doctor's opinion you are unable to meet the language requirement or the knowledge requirement. There's a separate knowledge requirement because of your medical condition. So the doctor will check off yes or no for which requirement and explain what the conditions are. So there isn't like a list of the conditions, but basically you have to provide medical kind of information. However, as I said, I believe very strongly that it is not just about cognitive disability. I think that we should be challenging that narrow interpretation of the Act itself. The Act talks about compassionate grounds, so that it's more than just cognitive disability.
Okay, so unfortunately we are out of time for more questions, and there are more that we didn't get to. You will notice on the webinar page there that there's an email, webinar questions@ocasi.org. And I encourage you, if there are other questions, we're going to keep track of these that were here. If there are other questions that you have that you think of later, please email this address. We're not sure we'll be able to answer them all, but we will keep track, and if there are definitely a number of people asking similar questions, we're going to try and find a way to respond to that, possibly with a question and answer page. And this presentation will be available. The webinar is being recorded and will be available on ocasi.org. And we'll also see about making just the PowerPoint slides available if you just want to do that with your staff. We'll look at having that on ocasi.org. So I really want to thank Amy for sharing her time and expertise. It's really greatly appreciated. This is our very first webinar, which we're very excited about. And we want to thank you for participating. A short survey will be sent to you tomorrow, and please do take the time to fill it out so that we can ensure we are providing high-quality webinars. All the feedback you have for this webinar is appreciated since it is our first one. So thank you so much, and hopefully we will see you in some of our future webinars. Goodbye, and signing off.